In this video, I'm going to be talking about the difference between the Speedy Trial Rule and a demand for speedy trial. It's a little bit complicated. You guys are smart enough. Let's get to work. The Sixth Amendment of the United States Constitution grants us the right to a speedy and public trial as part of due process. Okay, it sounds really good, but what does it mean? The Speedy Trial Rule means this. For felonies, at the time that you were arrested, okay, and charged, there is a imaginary clock that starts to tick. Well, it's not really imaginary. Actually, it begins to tick right at the time you were arrested, and the state or the government has 180 days to bring you to trial. That's your right to a speedy trial. However, if you as the defendant do anything to delay the trial, meaning you ask for a continuance, you need more time to work on a motion, you need another trial date, these are things that are called delays on the part of the defendant, and they would cause a waiver of that speedy trial. Now, a lot of defendants through counsel will get up right away in the beginning of a case and waive speedy trial at that time period. You'd say, why would somebody do that? Well, there's a lot of reasons. I'm going to go over strategy in a minute, but I just want to make sure everybody understands the rules that we're going to be dealing with. So 180 days, if you're not brought to trial in those 180 days, your lawyer files a motion. It's called a motion for discharge. And what that does is that puts the government on notice that that speedy trial clock I just told you about, it's up. Time is up. Now, the state has, or the government has 15 days from the time that motion is filed to get the defendant to trial, to get a jury sworn in. And if that doesn't happen within what's called the recapture period, the 15 days afterwards, then that case is discharged forever. Does that happen often? It does not. It's extremely rare to see a case discharged, meaning you can't be charged again. Double jeopardy attaches, and that's the end of it. Okay, that's the Speedy Trial Rule, and as I went over, it can be waived by actions, not just words. If you delay it in any way, it's going to be continued, and that speedy trial period, that 180 days, it's off the map. It's over. It's done. Now, there is something called a demand for speedy trial, and this is very important that you know the difference, because there's a very big case going on in Georgia. I don't know if you've heard about it. 19 co-defendants, right? And we're hearing, at least I heard through the idiot news that I sometimes put on, that one of the defendants, a lawyer, has demanded a speedy trial. His name is Kenneth Cheeseborough, and he has filed it because there's an October trial date that's set because he filed a demand. Now, here's what a demand does. A demand sets another clock ticking from the time that motion is filed. Basically, you're saying, I'm ready for trial right now. I'm filing a demand. The court has a hearing on it. And the court says, okay, there's a demand filed, state. And what that demand does is it gives the state 50 days. 50 days from the time it's filed to bring you to trial. So that demand for speedy trial is, forget the 180 now. You're demanding it through the motion, and there's another clock, a new clock that starts to tick. Why would somebody want to do that? Well, there's a lot of different reasons, but in this, let's use the 19 co-defendant case in Georgia. You have one of the 19 saying, I'm demanding a speedy trial now. State, you have 50 days to get me to trial. I don't care about the other 18 people. All right. That's a strategy. It's a strategy that can backfire big time. And let me tell you why this attorney probably filed that and what the strategy that what they're looking at, what they're trying to achieve with this demand. So what the demand is saying here is, I want to be tried separately from all these other 18 people, and I want to be tried first. Is that what you really want, Mr. Cheeseborough? Is that what you really want? Because the state could look at it and say, good, now we have somebody to test our indictment against. This guy Cheeseborough, got him on a couple of counts. Let's try him. He wants a speedy trial. Let's give it to him. Because the state is also looking at some things that nobody wants to talk about, such as, how much does a lawyer cost to file a demand for speedy trial and be ready to go? Because some judges will say, oh, you're filing that demand for speedy trial today, lawyer Mark? Yeah. Okay. Bring down a jury tomorrow. I want you here at 8 a.m. tomorrow. State, be here, ready to go. They filed a demand. This case has been on the docket for a year now. Let's see who's ready. And that can happen. That's a risk when you file a demand for speedy trial. There is that demand says that you are ready at any time in those 50 days. And if you're not, for some reason you get caught with your pants down and you're not ready, then that gets stricken. And that 50-day clock, that's over. The 180-day clock, that's been over for a while as soon as the continuance was taken. So there's a little bit of chicken involved. And the state is probably saying, you know what, this guy Cheeseborough, does he have enough money in his pocket to pay an attorney to be ready for the next 50 days to go to trial on an indictment that's going to draw worldwide attention? Because, folks, to get an attorney to represent you on a RICO in a case like this, any attorney that's worth their weight, that's a six-figure fee. A six-figure fee for a guy like Cheeseborough. Trial every day. This is taking the work of one or two attorneys to work on this. It costs a lot of money. That's why you're not going to see 19 co-defendants at the end of this thing, because very few, if any of these, except for the main co-defendant, have that kind of money to finance a defense, a RICO defense. Okay, RICO defense, that trial could go on for months. That's money. So when you use the speedy trial, you might be saying, I don't have enough money to drag this thing on. I'm going to bring it up tight. I'm going to use that speedy trial, the demand date, as a pressure point for the state. I want to see, maybe they'll come back with a plea offer for me to get me to withdraw my speedy. Maybe they won't. Maybe they won't give me any plea offer, and I'm going to be stuck going to trial on the 19th. But I can always withdraw with good grounds that demand for speedy trial. But some defendants and attorneys think, oh, if I file this demand, I'm really going to push the state. They're not going to know what to do. No, this DA in Atlanta, it's not her first rodeo. It's not her first RICO. She understands a lot of these little things that I'm talking to you about. She understands the demand and how he's going to try to separate himself. But they're ready for this. In fact, like I said, for some prosecutors, that would be a good test. All right, let's try this guy on some of our counts. Let's see how a jury accepts that. Yeah, we're showing our hand to the other defendants, but maybe we'll send a message and get a conviction on this guy. So if anybody else wants to mess around and separate themselves, you can look at what happened to Mr. Cheeseborough. I don't know what's going to happen. Maybe, for my own personal and my own, creative and curious use of a lot of these rules in my everyday practice, I am really curious to see how this plays out procedurally. Okay, not politically. That's all. You guys can talk about that somewhere else on TikTok. But procedurally, using the criminal procedure rules in Georgia, how is this going to play out? It's very different than what is happening in the federal cases, because you have these 19 co-defendants that can do different things with the speedy trial rule. All right, let's bring it back, all the way back to the beginning again. I've explained to you the speedy trial rule, 180 days from the time of arrest to get a defendant to trial, plus that 15-day recapture period. A demand for speedy trial on filing gives the defendant, telling the state, you have 50 days to bring me to trial. Again, there's a recapture period on the 50th day. It just doesn't disappear on the 50th day. There's basically a warning on that 50th day. There's a warning on that 180 days to the state, and there has to be a hearing where a judge says, all right, setting it tomorrow. State, government, be ready to go. This motion's well taken. This demand is well taken. So these rules are used in strategy. They're used by people who are in custody. I've had clients in custody like, can you speed this up a little bit? I'm sitting in here. We got a good case. And I'm like, yeah, all right. But, there's other obligations that a defendant has to be able to finance something like that. So I'll be back with some more videos. If this is helping out and you've lasted this long with me, thank you. Let me know in the comments. And like you, I'm curious to see how this all turns out.